If everyone could please make a start at heading to their seats, we'll begin in about a minute. Good afternoon, everyone. I hope everyone enjoyed their lunch. My name is Jessica Morris, and I am a family lawyer focused on AI and product development at Leap. Welcome to this session, Parenting and Transition, Risk, Reform and Re-Andrew. Today's panel brings together three speakers whose work sits at the intersection of law, practice, and the lived experience of children and families. The Honourable Justice Suzanne Christie was admitted to practice as a barrister in 2004 and appointed senior counsel in 2018 before her appointment to the bench. Her Honour has extensive experience in family law across state and federal courts, including adoption and appellant advocacy. Prior to her appointment, she was a contributing author to Halsbury's Laws of Australia and one of the authors of the LexisNexis annotated family law legislation. Our second speaker is Dr. Catherine Boland. Dr. Boland is a clinical psychologist with expertise in working with children, young people and parents experiencing family conflict and separation at her practice, The Relation Space. Dr. Boland has developed a therapeutic and reporting model for families ordered to attend therapy and is frequently engaged to provide expert opinion and reports to the court. Leap is proud to partner with the Relation Space to offer their course Relation Space Online to Leap users, which we encourage you to share with your clients. The code to access the Relation Space Online is LeapX Relation Space, and the details can be found in your goodie bags. Our third speaker is Karen Shea of Counsel. Karen specialises in family law and children's care and protection. Prior to coming to the bar, she practiced as a family law solicitor for 18 years and was a family law advocate at Legal Aid New South Wales from 2009 to 2018. She has extensive experience appearing in parenting, care and appellant matters, as well as adoption and complex proceedings in the Supreme Court. Karen also co-teaches family law advocacy and practice and children's law at UNSW. Please join me in welcoming our incredible speakers.
Good afternoon. Thank you for giving up your afternoon to listen to us. I'm going to be speaking to you today about the background to set the scene for what is hopefully an interesting discussion about whether or not the amendments to the Act in 2023 are likely to have an impact on the jurisprudence and how that fits with the expert evidence which might be led in cases which are about the Re-Andrew principles. So if we move on to the first slide, I'll give you an overview of where we're going today. What I want to do is, for most of you this will be very familiar, have a quick look at what the amendments are, at least so far as they relate to what we're talking about today. To then move on to talking about safety. We're going to have a quick discussion about where the concept of re-Andrew started and the key elements. We'll then look at some cases which have considered re-Andrew and how the law is developing before moving on to what it is that we mean by safety. Can I commend to you the written paper which accompanies these slides, and can I thank, as I have done in writing, my associate Minna Lu for her considerable assistance in its preparation. So let's move now to looking at the amendments. One of the things which you will see immediately is different from the way in which it was before the amendments is that in our objects section we have mention of the Convention on the Rights of the Child. That's an important point to remember, given that when we speak about these cases very much in terms of the applications which are brought by adults, at the end of the day, we're talking about determinations which affect children. Section 60cc has been slimmed down, and the considerations now are not primary and additional, but are listed in a way which suggests there is no priority. You'll note that I used the word suggests, and as we move to the case law later, there is a beginning jurisprudential suggestion that the structure of the statute is such as to put some emphasis on safety. Safety also includes obviously looking specifically at family violence, but it is much broader than that. There's a codification in a separate section of children's right to enjoy their Aboriginal or Torres Strait Islander culture, a codification of rice and asplund, changes to the law as they relate to independent children's lawyers. I've put up there, independent children's lawyer must meet with the child unless an exception applies. And in a re-Andrew context, the first exception that occurs to me is children who are enmeshed in a parental narrative, and whether or not that might, in an appropriate case, be a basis upon which an independent children's lawyer might decline. One can imagine, however, how frustrating that would be for a child who is told that he or she can't meet with their independent children's lawyer because it is perceived by the independent children's lawyer that to do so might be systems abuse. A difficult area. And then there's a repeal of the presumption of equal shared parental responsibility and the need for judicial consideration of equal time or significant and substantial time. So let's move then to safety. When the explanatory memorandum was published, it said the bill will make a number of amendments to simplify and clarify the pathway for decision making in determining parenting arrangements to ensure that safety and best interests are squarely and unequivocally the focus. So the statute says what arrangements would promote safety. Interestingly, promote is been specifically chosen. It's not the same as ensure, and that's perhaps interesting when we come to consider the scope of what we mean by safety. And secondly, and very importantly, the statute says safety of a child, but also safety of a person with caring responsibilities for a child. So it's disaggregated. One need not now think only of the safety of a carer through the lens of safety of the child. The statute permits independent consideration. The type of safety that we're thinking about is physical and psychological. It occurs to me that one of the interesting aspects is that the same arrangement may not promote the safety of an adult and a child, as in their needs may be different. So let's turn now to the re-Andrew principle itself, and I want to tell you about Andrew and his family. Andrew's parents separated when he was 4 months old. He spent regular time with his father post-separation until an incident when his father lost his temper, used offensive language and threatened the mother. At a changeover, time stopped. After that, the father threatened suicide. There was a serious further incident of which the father was convicted. He grabbed the mother by the throat. The family court judge found that this was an isolated incident. The matter went on appeal, and the principles which emerged were reached after consideration of a report. The report said that Andrew enjoyed each access visit and enjoyed being with his father, but felt a bit guilty about that. The report also said Mum would be afraid and find it impossible to encourage his attendance. The mother genuinely held a fear that the father wanted to kill her child. And it is from that case that we mark the development of what has come to be referred to as the Re-Andrew principle. It is a case generally where the children's parent, there is an allegation of abuse. One of the children's parents is suggesting either supervised time or no time to the other parent. The other parent is probably suggesting they have time or a change of residence. The difficulty that arises for the court in this particular situation is that it is not always clear which of these options is best for the child. Arising out of the case, some principles are set out there on the slide, headed key elements. The first thing that we need to consider is whether or not there is actually a physical risk to the child. Oftentimes these cases will involve allegations of either sexual abuse or physical abuse, or may arise out of family violence experienced by the carer. It is interesting that we start by saying there has to be no objective evidence establishing that safety risk, because when we revisited the Re-Andrew fact scenario, you can see that there was some evidence supporting there being a risk to safety. So the question then is not perhaps as simple as no objective evidence establishing the safety risk, but no objective evidence establishing the nature or degree of the safety risk. There is often a kernel of truth from which the rest of the scenario emerges. There must be a genuine belief on the part of the parent that the other parent poses a safety risk, and a consequent impairment of parenting capacity. Now, the impairment may be that that parent cannot facilitate the relationship with the other parent. It may be that it presents as anxiety or an impact on functioning. The impact on parenting is essential in order to determine that this is not in the interests of the child. So let's turn then to the next slide. There's a quote set out here from Russell and Close. There needs to be a genuinely held belief that a parent poses a safety risk. If there's a doubt about the genuineness, when we probably don't have a Re-Andrew case. So it can't be a case about I'm a better parent, it can't be cynical or tactical, it can't be disingenuous opportunism or lingering doubt. It has to be conviction. This person is a threat to my child and I am unable to see anything other than that position. Let's move to the next slide. So when we talk about impairment of parenting capacity, it will be a question of fact based on the evidence. The evidence may very well be expert evidence. The impact on parenting might be anxiety. It might be I cannot function per se. I cannot get out of bed. Sometimes the case law says it's an impact on co-parenting capacity, as in I cannot parent with the other parent. And sometimes it will be an incapacity in terms of that parent's capacity to emotionally support their children. But there needs to be a link to impaired capacity. Let's turn to the next slide. These are just set out as examples of cases in which the judge has found that there was no objective evidence establishing a safety risk, but the parent alleging the safety risk continued to maintain it. In Reandrew, as I said earlier, the judge found there was no direct risk of physical harm to the child, notwithstanding the violence which had happened between the parents. In Russell and Close, the judge found there was no risk of sexual abuse. That was the position too in Arrighetti and it's very difficult to pronounce, I'm not sure, Kodorova and Moss and Moss. And then again, no unacceptable risk of physical harm in this more recent case of Arends and Pilkvist. So then turning to the next slide, there have been some appellate decisions since the amendments. The first one on the slide is a decision called Arends and Pilkvist. These are tragic factual circumstances. There was a car accident which was responsible for the death of one child, and it had an enormous impact on the arrangements for the surviving child. The mother felt that her child would genuinely be at risk of harm if that child were to spend time with a father who had, by that stage, finished his prison sentence related to the death of the other child. It was found that there was no direct unacceptable risk of harm to the child, but the impact of having to facilitate that time on the primary carer was sufficient to prevent orders for time. The next decision, which is on the slide, is a decision called Hannigan. It's an interim decision, and I've included it for this reason. It's very difficult to make any findings of fact at an interim hearing. However, we do need to consider these types of issues even at interim hearing, and the full court in that particular decision found that it was appropriate to err on the side of caution, even if the risk you were protecting against was decompensation on the part of a primary carer. Let's skip to the next slide, which compares two different cases. I'd like to offer a caveat. When I say I'm comparing two different cases, I would not want that to be seen as a suggestion that when you put like scenarios next to each other, you ought end up with a like outcome. The full courts told us that many, many times that the broad nature of the discretion which we exercise is such that two cases which appear similar may end up with different orders, both of which are unassailable. So the two decisions up there are Arrighetti and Kodorova and Moss and Moss. And if we skip to the next slide, I'll say to you why I think we get different outcomes, and that may be a subject we wish to discuss in more detail. We get different outcomes for this reason. The statute isn't limited to safety only, and the content of safety is not prescribed. Next to safety, we put every other statutory consideration. So some of the other really important statutory considerations are age and development stage of the child, nature of the child's relationship with each parent. You are probably going to find a psychological risk in taking away an older child from a parent with whom they have lived their whole life. Whether the parent whose views are not objectively established experiences challenges in other spheres except not just confined to the other parent. So it's a matrix in which you decide of the options available to me, which one will best protect. And I think in this case we're almost always looking at psychological safety. So which is the arrangement of these two arrangements which is most likely to be safe for the child? Now, I just want to very briefly touch on this because my two next speakers will be saying things far more interesting than anything that you've heard thus far. So, don't let us forget that we may well have need to make reference to the Convention on the Rights of the Child, but to the extent that there's a controversy at the moment, have a look at the decision of Arrighetti and have a look at the explanatory memorandum. Next slide. On the next slide, you will see exactly what the statutory language is for section 60cc 2A. I want you to have that statutory language in mind when you listen to the next two speakers. Let's move to the next slide. What does it mean to promote safety? Is the promotion of safety different from protection from harm? Perhaps the full court in due course will express an opinion about that, but let's open up the discussion about that topic. Catherine.
Thank you. As you were talking, Judge, I thought what a difficult job we all have to do, actually, predicting the future, preventing harm or promoting safety, and sort of features that are incongruent with raising children and living life, really. So I'll give a clinical perspective about these cases. And I think one of the differences in our disciplines in this context is that as legal practitioners, you have to consider the issues that you've just heard about whether a parent has a genuine belief and whether that genuine belief impacts on their parenting capacity. Clinicians don't think in those terms. What we think about is how parenting belief organises parenting behaviour. And if you have a belief system that is organised around fear and anxiety, your parenting behaviours, in fact, all of your behaviours, have a veil of hypervigilance, surveillance, avoidance, a risk-based scenario in every interaction you have with your child and with the world at large, which the child or children are absorbing. And I think that has a significant impact on children's development, a very significant impact, to the extent that it can very harmfully interrupt a child's ordinary, normal and healthy development. And so that's where I sort of focus my attention as an expert and also in clinical work with parents. Can you just flick on? It's odd not driving your own slides. I don't know if I like that. So from my perspective, the issue is not belief alone. In fact, almost every parent I see, well, not everyone, but most of them, their beliefs are genuine. They genuinely believe deeply that their child is at risk, that something bad is going to happen. And yet I'm not interested so much in that. I'm interested in how adaptive or functional their parenting behaviour is. So in simple sort of cognitive science terms, we can say that we all have beliefs, and if your belief system is a perception of threat, you will have a particular parenting response, and that has an impact on the child. And so I'm interested in what the child experiences as a result of this parenting response. And if genuineness of belief is not a proxy for whether parenting is adaptive, whether the assessment of risk is proportional, which is a really useful term for you to think of in every interaction you have with parents. Is this proportional? Is the anxiety or fear relatively appropriate for the risk? And that's a value judgment, and it's a judgment that changes across generations, but it is a judgment that we have to make. And also the impact on children. So moving on. Specific parenting behaviours that arise from maladaptive risk belief systems. So that is when parents have a belief system that is disproportionate to what has happened, that is intractable, that will not change despite often heaps and heaps of investigations and evidence to the contrary. So a fixed, unswayable belief. We've all seen parents like this. They develop very rigid thinking styles, and it's impossible to dissuade them. Unfortunately, we now live in a world where this is quite common. We have people who have very compartmentalised belief systems, rigid, and it seems to be that we understand a lot now that trying to argue your way out of that or convince someone that their belief system is inaccurate usually backfires. So what we see in parenting specifically are these sort of attributes. The appraisal of threat, I talked about disproportionate as being a really useful word. And what that means is that their perception of risk exceeds anything objective. So they've got intolerance for anything that is unknown, or they see magnified risk in ordinary, average situations. So when their child has different behaviours at transition, return from the other parent's house, so the toddler is having tantrums or refusing to eat or wets the bed, or anything within the realm of normal toddler behaviour at a transition, the parent appraises that with a threat-based scenario, which means something terrible has happened. This child is expressing trauma. Something really awful is happening to this child, and it's disproportionate in and of itself. That scenario I've described, children behave like that at all sorts of transitions. Children in intact families behave like that. That's how toddlers behave when something new or different is happening. And certainly when your parents are separated and you have to transition between households, those behaviours are normal markers of a child's transition stress. But a parent with a disproportionate threat appraisal will immediately interpret that as the child displaying symptoms of trauma. Even the language is, that's the sort of language you get. Then the other feature of this maladaptive belief system is that the safety concerns remain unchanged no matter what corrective experiences happen. So these behaviours lessen over time, or the child expresses enjoyment, but the belief is fixed and rigid and the threat appraisal remains. The other thing that this maladaptive risk belief system operationalises as is binary framing, so a catastrophic interpretation of minor events. So he is an abuser and everything is seen through that lens. If, for example, there's been a situation where a parent has done, I'm trying to sort of describe ordinary, average, less than ideal, just bad parenting behaviours. Like, bad parenting behaviours exist in every household in Australia. People lose their temper. They do really stupid stuff, regrettable things. So when a parent loses their temper and the child reports on that, someone with this maladaptive risk belief system will immediately assume, again, that child has been exposed to an unacceptable, dangerous, threatening level of risk. And so, don't interpret me incorrectly. I'm not suggesting that being angry and losing your temper is a good thing. We're well advised to avoid it, but we're also human. And so the human aspect of parenting is interpreted through this lens. And finally, this resistance to updating, which is a clinical feature of most of the parents we see. So it doesn't matter what happens. We can write a report, we can give a judgment. You can have years sometimes of supervision reports. You can have reports from teachers, other people, step parents seeing that the child is enjoying this experience, or there's just nothing but a loving, normal, maybe less than ideal, but an adequate enough parenting relationship, and that is all dismissed or minimised. She's only happy because he buys him this present, or there's alternative interpretations for everything that new information is gained. So moving along. So what happens, what actual parenting behaviours do we see when people have these maladaptive sort of belief systems? Chronic hypervigilance and persistent threat scanning. We see it in our office from the moment parents walk into the waiting room. This is going to be, we've told them, of course, parents are anxious when they come to see an expert. We have child-friendly rooms. Kids are really happy to see the toys. They go into a playroom, the parent immediately, are you going to be okay? I'm just here. Don't worry, I'll be just here. We get these effusive expressions of goodbye, the farewell that goes on for 20 minutes because they're just coming into my office, is an example of persistent threat scanning and chronic hypervigilance. And, before I said children are, they get the vibe. Children pick up on the vibe very, very quickly. And this happens all the time, over-checking, and there's a myriad of ways to do that these days. Are you going to be okay? Don't forget this. What's going to happen next? Make sure this happens. Look after your younger brother or sister. Text me back. Put the tracking on. There seems to be infinite ways that parents will be hypervigilant. When children come back, what parents with this parenting style will do is forensic style questioning about everything. What happened? What were you fed? Why are you wearing those clothes? What time did you go to bed? What did he say? And on it goes. And children become very, very used to this sort of reception when they arrive back from time with the other parent. So earlier, minor events are interpreted as confirmation of danger. How much sunscreen was put on? What sort of style of drink bottle did you have? Was it one with the plastics or not the plastics? Or what sort of food were you given? So ordinary, everyday behaviours are interpreted as a dangerous thing. The parent is hypervigilant for mistakes and is putting the child in the position of having to be the informant. Preloading the child with warnings and anticipatory anxiety. So make sure this happens, make sure that you don't eat this, make sure that your sister doesn't do something. And these can be explicit, but most frequently they're sort of implicit in the instructions that the parent gives. Children in these scenarios, and there are many of them, are left in a position of being both informant on the parent, but also protector of the receiving of this parent's anxiety. They are the ones who are reassuring that parent that they will do all these things and then everything will be okay because mum or dad won't be worried anymore if I do all these things, which of course puts the child in an enormously burdened position being triangulated between the parents. And they then very quickly absorb the fear. So anxiety has a very strong heritable component. So if you have the genes for anxiety, which many of us do, not bad genetics to have, make you very conscientious, but you're also absorbing anxious and avoidant behaviours in your environment, so you get the double whammy. So these children very quickly develop anxiety disorders and develop a maladaptive risk appraisal themselves, which sort of spills over to many other areas of their life, which is a big problem in terms of their safety and their safety of their healthy development. And the other thing that I think we're all familiar with is the avoidance or the withdrawal of the child from developmentally healthy experiences, like going to school and staying the entire day, going to school every day of the week and staying the entire day, not being withdrawn from school at 2:30 so that grandma doesn't accidentally come and pick you up. That's a really developmentally abnormal experience for a child, and it teaches a child a very strong message about the world. Withdrawal is the antidote to fear. And of course, what we know very clearly is that avoidance is the gateway to escalated anxiety. the treatment, the gold standard treatment for anxiety is not avoidance, it's graded exposure. It's standard, but in family law we sort of do the opposite. It's my little bugbear. Can you flick me over to the next slide, Karen? Thanks. All right. And so what happens to these kids? Well, as you would imagine, they become hypervigilant themselves and they develop anticipatory anxiety. They don't want to go to the other parent's house. And, you know, I could talk at length and won't bore you with the way that parents selectively reinforce children's responses. So it is quite easy, and I don't think that this always happens in a calculated way, but it is quite easy to reinforce in a child avoidant behaviours and not wanting to go to a parent's house. I've seen it happen in as little time as a couple of weeks, probably less actually. Children are highly malleable. They want to please their parents, and particularly parents with whom they feel responsible for their anxiety. So these children develop hypervigilance not just for risk in the world, but for how is my mum or dad coping, and I am responsible for managing that stress. Because when I do the right things, she stops asking these questions, or she relaxes and goes back to being a kind of normal mum or dad. What these children set up with is the world is a dangerous, scary place and I can't trust myself. And not only can I not trust myself, I can't actually trust other adults outside this primary attachment figure. It's a very dangerous predicament for children to have that frame of the world. Also, there's a huge role reversal. So the child becomes responsible for regulating the parent's anxiety. Problematically for children, what happens when they've actually had, which is usually the case, a really good time at the other parent's house, or they've enjoyed the relationship with the step siblings or the step parent, and they really, really like grandma. But they can't say that because to express that arises this enormous anxiety and particular parenting behaviours from the other parent. So what do they do with that authentic experience? Well, they suppress it, they start to feel confused about it, and they start to do mental gymnastics in their mind about reliving that or replaying that in a way that gives them cognitive distortions about their own experience. It's sort of like, you know, to use the phrase that I really hate, it's like they're gaslit the whole time. And it's a big problem to have a cognitive distortion reinforced. And I don't think I need to tell this audience the number of children that have developed beliefs about things that have happened which did not happen and how dangerous that is. And that can be done in the systems that we create. It can be done in the agencies that we send them to, and it's a problem. And again, I think I talked earlier about my dislike of avoidance and withdrawal as the de facto position for managing anxiety. But that's what these children are learning. So finally, what can we do? I think that the first thing we need to understand is that healthy child development requires managed risks and graduated exposure. Most parents I see are good enough parents. And that's a really helpful term. We somehow, when we see clients, come to us with an expectation that what their children need are the most optimal, gold standard, perfect parenting. They need a clinical psychologist running the household, a doctor, someone giving every child an optimal, perfect experience. And that does not help children's healthy development. You can ask my children. We need parents to make mistakes. Parents lose their temper. Children lose their temper. Children need to be upset sometimes, to cope with disappointment and boredom and things that are not fun. and things that they would rather not do. This is the hallmark of healthy life development. But sometimes the clients with this maladaptive kind of thinking have an expectation that any time my child expresses distress, it's a symptom of trauma. It's a symptom that something terrible has happened or will happen, and it is not to be tolerated. Not only not to be tolerated, but I have to operationalise all my systems to remove a child from the thing that I think caused that experience. And so this is a big risk for children's development. In general, children that are kind of put back to the legal cases we were talking about, kept in that situation, they don't have contact with the other parent, they don't have contact with the other parent, their extended family, and often many other people who are not true believers, if I can use those terms, they then have very poor distress tolerance themselves. You often see it play out in scenarios where these are children who can't cope with fractures in their peer relationships. So they have huge bust-ups with their friendship groups, parent swoops in and tries to help, and they can't tolerate, because kids aren't going to operate by this same framework. They also develop this externalised locus of control, which is dependent on an adult to solve my problems. So I can't cope and do things. I'm basically an incompetent agent. I can't manage challenging situations on my own. Very frequently, these children end up with problematic personality styles. I don't want to say disorders, but it is the gateway to disordered personality functioning, because if someone doesn't disagree with you, you split and you eradicate that person, and you develop a pattern in your relationships of not being able to cope with people who disagree with you, people who do things that are ordinary and hurtful, which is all humans and all interpersonal relationships. And these children are a significant risk of anxiety disorders in particular, but also depression and mood disorders, and as I said, the sort of segue into personality disorders. Can you give me one more slide, I think? So in these type of cases, I think as Hirona talked about, the first job of the system that we are all in is to assess safety. Of course, children need to be in situations where safety is promoted. I find the terms very difficult to grapple with as a clinician who has been trained in risk mitigation, because promotion of safety is almost like an endless term. If we really promoted safety, no one would have children. No one would be in relationships. We certainly wouldn't send them to school or out in the world. So at what point are we saying, come back to this word proportional, at what point do we say as an individual, as a society, as a legal system, that this level of safety is the right level of safety? I'm still grappling with this. I don't have the answers, but there's some level of sort of unsafety, if I can call it that, that is part of life. And proportionality is sort of the best clinical proxy for that I can come up with. We want, as a forensic assessor, I am looking at how available is this parent's thinking style to be modified. Is there so much rigidity that it doesn't matter what evidence there is, the belief and therefore the parenting behaviour will not change? And often I just ask parents point blank, what would it take in the other house or for the other parent to do that would make you feel that it was safe? And most parents cannot answer that question or a variant of that question. It's actually a really good question to ask, because you say, well, they've done the courses, we've had the reports, I've observed the child, I've read the reports from teachers. What would it take for you to feel that they would be safe? And the answer is frequently nothing. So I know that there's a rigid, fixed, unswayable belief there, if nothing is going to change it. Her Honour sort of touched on this earlier. I talked about the spillover effects. There are some cases where this maladaptive thinking and parenting style is very, very contained to only that child's experience in the other parent's house, but the parent is able to allow the child to be exposed to appropriate developmental risks and to other people, extended family and so on, but frequently it's not. So we're looking at how widespread is this parenting behaviour and therefore the child's world. And I sort of think, finishing, I would say we have to be careful about whether we are actually promoting safety and protecting children from harm, or are we protecting a parenting belief system? Are we protecting perhaps a genuinely held belief about risk that is disproportionate and not in the child's best interest? So the few things that are available to us, staged intervention, therapeutic intervention, and ensuring that the child has exposure to the wider, I was going to say wilder, but maybe that's a better word, the wider, wilder, unsafe world. All right, Karen. That's it.
Thank you. Ironically, they gave the control of the screens to the person with no screens. I apologise, I have no PowerPoint, but what I wanted to just spend the rest of the time we've got talking to you about is the practical implications for us as legal practitioners, and how to run a re-Andrew case for a resident parent, and on the other side, how to oppose a re-Andrew case for the non-resident parent. And at the outset, can I say this? They are difficult cases both to run and difficult cases to oppose. Can I suggest, firstly, we come back to the three key elements that Justice Christie identified earlier, which are great in providing a basic framework for both sides of the argument. And the three basic elements were, firstly, whether or not the resident parent poses an unacceptable risk objectively. Secondly, if not, whether the resident parent nonetheless holds a genuine belief that the other parent poses an unacceptable risk. And then thirdly, if so, would orders for time have such a negative impact on that parent's parenting capacity that it wouldn't be in the best interest of the child to make such orders. So those are the three elements of a classic re-Andrew case, and that provides the structure for your case theory, whether you're acting for a resident parent or a non-resident parent. Now, I love talking about case theory. This is not the time or the place to do that, but really think about it, because as lawyers, case theory is the key to success, might I say. But so if we look at acting for a resident parent first, your case theory would basically be this, that firstly, there is objectively an unacceptable risk. Secondly, but even if the court is not satisfied about that, then the court would be satisfied there that your client has a genuine belief that there's an unacceptable risk. And thirdly, because of that belief, if the court makes orders for time, your client's parenting capacity would be severely compromised such that it wouldn't be in the child's best interest. So that's your basic case theory. Once you've got that case theory, then you can think about what evidence you need to prove each of those three elements. So firstly, remember, you are still running an unacceptable risk case. You can't just concede that there is no objective evidence of an unacceptable risk. Okay, you can't skip stage one and go straight to the genuine belief, because that would undermine the genuineness of your client's belief if they're not even prepared to try to run the argument that the court would be satisfied objectively that there's an unacceptable risk. So you've got to try to run it like a normal unacceptable risk case, if I can say it that way, right? You've got to try and establish an unacceptable risk as best you can on the evidence that you've got. And if you're successful, then the issue becomes how to mitigate, and you go down that path of an ordinary unacceptable risk case, if there's such a thing. You don't need to go down the path of genuine belief and impact on parenting capacity because you've established unacceptable risk in the usual way. Right? But if you're not successful, then you're down to number 2, right, which is the issue of whether the client holds genuine belief that there is such a risk. Obviously, evidence of genuine belief is important, but also how your client conducts their case is important. And comes back to something that Justice Christie said earlier. Ideally, your client would conduct their case from as early as possible in a manner that is consistent with them holding a genuine belief that the other parent poses an unacceptable risk. And so, for example, if your client has proposed or facilitated unsupervised time, either before proceedings commenced or at an interim stage, we've all seen this, right? It then becomes very difficult for them to argue that they have a genuine belief that the other parent poses an unacceptable risk. Not impossible, but it is a hurdle that they have to try and overcome. If they have done that, that is, if they have facilitated unsupervised time, and now say they say there can't be any time because I'm just not capable, they need to explain why they did it in their trial affidavit. They need to give some real thought to explaining in their own words why it is that they went down that path, and there could be a myriad of reasons. It needs to be an authentic explanation, though, so not yours, their own words, because undoubtedly when it comes to the trial, they will be cross-examined on it. Right? If you are so concerned that there's that the other parent poses a risk, why did you facilitate unsupervised time when the child was so many years younger? So they're going to have to explain it, but get the clients to think about it themselves, talk them through it, and get them to use their own words to explain why they did it. And in some detail, not just, I felt pressured or something like that, but a bit more than that. And you certainly want it to be an authentic explanation, that is their own explanation, because you don't want them to be caught out in cross-examination with a piece of evidence in the affidavit that isn't their own or isn't something they understand or adhere to. Other evidence you'd need in terms of genuine belief are things like what actually is it that your client believes about the other parent? What is the risk that they think that the other person poses, and why? Again, get them to think about that and articulate it themselves. It's more compelling that way. Simply saying the words in a trial affidavit, I hold a genuine belief, is not enough. Okay. Also, of course, you need expert evidence, and in particular, you're going to need evidence from your client's treater. It's important in these cases as early as possible to ensure your client has an appropriate treater, preferably someone with experience in this jurisdiction, and you can certainly, as practitioners, assist them by making an appropriate referral. There's no point sending them to somebody who's not going to be prepared to write a report and not prepared to be cross-examined, because you're going to need that evidence. But by the same token, please make sure your client doesn't go off and just look for someone just to write them a report, because that's not the purpose. The purpose is to get them some treatment, to try to deal with or overcome those beliefs in the way that Dr. Boland has talked about, to see if the unshakable can be shaken or moved, all right, or managed in some way. That's the purpose of it. And they have to genuinely want that treatment and be committed to it. Otherwise, it's problematic to send them off for it. When you, as practitioners, write to the treater, and please do it in writing, please don't ask for reports orally. When you write to a treater to ask for a report, of course, you all know you have to comply with, or the treater has to comply with Rule 7.01. But I think as the practitioner asking for the report, you have to try and be a bit creative. And I'm going to regret saying this in front of Justice Christie one day, but not just send the standard letter that I see time and time again, What are the dates of attendance? What's your diagnosis? What's the prognosis? And what are your recommendations? Everyone seems to write that bog standard letter. Well, not literally. I didn't run this bit past Justice Christie. I think you need to look more closely at the rules. Maybe this is a whole topic, another topic for another day. I think you need to look more closely at Rule 7.01, and I think you can actually craft some more specific questions. Because Rule 7.01, and particularly Sub-Rule 1, there is some breadth to it. So, for example, Sub-Rule 1A1 is the results of an examination, investigation or observation. So you can ask about their observations. What are your observations? What symptoms have you observed? And what impact do you think those symptoms have? Right? That's a question, a more specific and more targeted question than just diagnosis. Because sometimes it's not just about diagnosis. It's about symptoms, it's about presentation, it's about demeanour. So try to get your... Because otherwise, if you just ask what's the diagnosis, you'll get one line back saying anxiety. Well, that's not going to help you very much, all right? Similarly, with the Sub-Rule 1A3, expressions of opinions limited to the reasons for carrying out or recommending treatment and consequences of treatment, including prognosis, certainly ask what the prognosis is, but in my view, and this is just my personal view, ask whether the prognosis is conditional on anything. Right? Because if it is conditional, you want to know what those conditions are. So, for example, if your client's prognosis is they'll make a full recovery, or they'll be able to, be mentally very well and stable, provided there is no involvement of the other party, then it's important for that to be in the evidence before the court if you're running that case. Right? So I think with a little bit more specific and a bit more thought as to the questions you're asking your treaters, you might get a bit more useful evidence. Obviously, it depends on how the treater answers those questions. The answers might ultimately be the subject of objection, and you'll then have to persuade the trial judge, Justice Christie, to admit the evidence, and you may or may not be successful. But if you don't ask the question, then you don't have the evidence in the first place. You've got no chance of getting it in, right? Whereas if you at least ask the question, you get the evidence, you've got some chance of getting it in. Obviously, treaters' evidence will not only go to genuine belief, but also to impact on parenting capacity. And that, of course, takes me to the third element of that structure, that case theory. It's important to remember here, it's not just impact on the resident parent's mental health, it is impact on parenting capacity, which is much broader than just mental health, as Dr. Boland's just talked about. And I don't think I need to... Dr. Boland's talked a lot about the impact of stress, anxiety and fear on a person's functioning, things like that. But I think what is important, and this comes back to your client's own evidence, is for them to explain that impact in their own words and really grill them on it. Drill down, how does this fear of the other parent affect you day to day? How does the stress affect you? Does it mean you don't sleep well? Does it mean you don't have energy? Does it mean you can't concentrate? Does it mean you don't think clearly? You lose your patience? Your mood is affected? You don't feel like going out? All of those things affect a person's parenting capacity, or can, right? So again, it's for you. The onus is on you as the practitioner to drill down and get them to think about impact, really think about how it's impacting their lives. And also ask if the client has noticed whether it's affected their interactions with their child. Ask them to give examples. Find out if they have any underlying vulnerabilities that are exacerbated by the stress and anxiety and fear of the other parent. Even if it's a physical health issue, they might have a physical health issue that is made worse by the stress, anxiety and fear of the other parent. And that physical health issue may then have an impact on their parenting capacity. So really drill down about it and talk to the client, get them to talk to their treater about it. Also talk to close family members, particularly if grandma, sister, grandpa has had to step in at times to pick up the pieces or help with the parenting when your client has been so incapacitated by the fear, stress and anxiety, because that really shows impact. Okay. Now, often clients are reluctant to give this evidence because they don't want the negative impact on their parenting to be used against them, and that's understandable. But you're not going to succeed on a Reandrew case without evidence of negative impact on parenting. And that's why there are risks involved in running this sort of case. The resident parent does need to show, and Dr. Boland alluded to this, that they are able to function and meet the child's needs in all other respects other than when it comes to the child's relationship with the other parent. So the child's needs need to be otherwise being met. They need to be going to school, they need to be socialising with friends, engaging activities, otherwise growing and developing well, apart from this, okay? There is a risk in running these cases. And that's where I'll turn in the last couple of minutes to the other side, and the risk is that the other parent, in response to your Reandrew case, will seek a change of residence. Right? That's the risk. So if you're acting for that parent, your case is, objectively, 1, objectively there is no unacceptable risk. 2, resident parent doesn't hold a genuine belief, it's completely irrational and baseless. And 3 can go in 2 ways. 3, depending on whether they're actually seeking a change of residence or not, because some parents in responding to a Reandrew case won't seek a change of residence. Some will, some won't. So your number 3 is either the resident parent is not so severely compromised that they can't cope and they can't, that orders for time would not be in the child's best interests. That's if you're seeking orders that provide for the child to continue to live with that parent. The other side of that is, if you're seeking a change of residence, what you're going to be arguing is the fact that the parent holds those views and the unshakable nature of those views places the child at risk, and that's why the child needs to be removed. So hopefully you can see how there's 2 ways, 2 ways you can go with that third element. I'll focus really briefly here on that last element. Obviously, the risk of a change of residence is something that you need to advise your client about if they're the resident parent. I think the extent of the risk of a change of residence will depend on a number of factors, including the extent of the impairment of the resident parent's parenting capacity, but also on the other side, whether the non-resident parent has good enough parenting capacity. And importantly, whether they're capable of supporting the child's relationship with the other parent, because the last thing the court will do or wants to do is to have it do a flip of residence only for the child not to have a relationship with the other parent. When you're acting for the non-resident parent seeking the change of residence, number of things to think about with your evidence. First question is, how do they intend to implement the change? Starting from the very basics, how's the transition going to occur? Where? When? Who's going to explain it to the child? Particularly if the child hasn't spent time with that parent for a significant period and is resistant. Where are they going to live? Where are they going to go to school? Is there going to be a moratorium on contact? If so, how long? It's really important for a parent in this position to show they have insight into the impact on the child of that change and how they propose to manage it. Have they sought some professional advice? If they haven't, send them off to get some professional advice about how to manage the transition. Have they got some professional support lined up for the child? Will they take time off work so that they're available for the child? Do they have other supports like grandma or sister or brother or somebody who the child will, someone to be a buffer? Right, so it's not just them and the child in this really difficult period. Get them to think about how they'll support the child's relationship with the other parent, what are their proposals, and also make sure that they are able to demonstrate, both in their affidavit and in the witness box, a positive attitude, okay, to the other parent, notwithstanding everything that has happened and the belief system of the other parent. So you really have to show that your client is a viable candidate for residence, and you really have to convince the court that they have the capacity to provide an emotionally and psychologically safer environment for the child than the other parent. And I'm 1 minute, 9 seconds over time, so I'll stop there. Thank you.
Yes, thank you again for that really informative session. If everyone could just stay seated, we'll set the stage up for the next session.